If you lose custody, how long do you have to wait before you can appeal that? It's a good question. My name is Goldman. I'm the director and founder of Goldman & Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. That's a good question. You lose custody, you're upset about it. How long do you have to wait to appeal? Well, generally speaking, appeals can be filed quickly, and they should be, because usually if you want to claim appeal to the Court of Appeals from a circuit court decision, you usually got 21 days to file that claim of appeal. So you got to do it quickly. But remember one thing, what does an appeal do? An appeal is not a chance to retry the case. In the appeal, the Court of Appeals is going to look for error that was committed by the court below. In other words, it's not whether or not they agree with you, but it's whether or not the court abused its discretion somehow in finding what they did. I cannot tell you how many times I've read opinions before the Court of Appeals and have heard the Court of Appeals say, if we were there, while we might have ruled otherwise, we do not find that the lower court made a mistake in coming to the conclusion that they did. So in other words, it's not like you got to convince them that they would have decided differently. You got to convince them that that guy made an error of law. That guy abused his discretion. That lower court judge made a legal mistake. That is not so easy to do. Now, remember one thing. It might be better, rather than go to the Court of Appeals to try and meet that high burden, it might be better to try and simply modify the custody order at the lower level. In other words, okay, so you lost custody. But now a few months down the road, you can come back before the court and move to modify the custody arrangement, maybe give you more time, make it more even. It'll probably be easier and maybe even quicker than taking an appeal, because, you take a Court of Appeals, it could take 8, 9, 10 months before you hear from them. Filing a petition to modify before the same judge, that may be a quicker way to go. You want to focus on what's in the best interest of the child, not proving the court wrong. You want to focus on the things that really matter. When you show the court that you're really concerned about what's in the child's best interest, the court can look at it and say, all right, in light of that, let me modify the ruling. If you're going to focus primarily, a judge, you were unfair to me, you did something wrong, you probably won't get the same level of traction. Obviously, every case is different. If you feel that you have been inappropriately treated in your case and a modifying petition or an appeal may be appropriate, reach out, let's discuss it. We'll be glad to see if we can help you out.
248-588-3333. 248